The man who showed up on my porch to evict me was wearing a badge. It was gold-colored plastic, the kind you can order online for $32. And it said Community Standards Authority in raised letters around the edge. He had a clipboard. He had a polo shirt with a logo on the chest. He had a voice that was used to people backing down. He did not know whose porch he was standing on. Let me tell you what happened, and I need you to stay with me through this, because what this man did, what he thought he could do, is something I had never encountered in 31 years of law enforcement. Not once. I've seen criminals bold enough to look a deputy in the eye and lie. I've seen developers bury easements in paperwork, but I had never, until the morning of September the 7th, seen a man walk up to a house in my county, flash a fake badge, and tell the owner they had 48 hours to vacate. I want you to remember one thing from this first moment. That badge, I want you to keep it in mind, because the story of that badge does not end on my porch, not even close. What would you have done if someone came to your home with a badge and a clipboard and told you the HOA was taking over? Tell me in the comments, because I still think about what would have happened if that had been my grandmother standing there instead of me. My name is Elroy Beaumont. I am 58 years old. I am the elected sheriff of Lafourche Parish, Louisiana. And this is my house. Let me back up. Let me tell you who I am and how I got here. I was born in Thibodaux. My people have been in Lafourche Parish for 5 generations. My grandfather, Clarence Beaumont, worked 40 years as a sugarcane labourer before he saved enough to buy a half-acre plot of Highway 24, a piece of land that was not in any subdivision, not in any HOA, not in any planned community, just a rectangle of Louisiana earth that he paid cash money for in 1951. He built a wood frame house on it. He raised 6 children in it. And when he passed in 1979, he left that land and that house to my father, James Beaumont, in a properly recorded deed at the Lafourche Parish Courthouse, Deed Book 441, page 87. I know those numbers by heart. I have known them since I was 12 years old. My father added onto the house in 1984, enclosed the back porch, added a second bathroom, poured a concrete driveway that we both worked on together that summer, with rented equipment and our own backs. I remember the smell of the concrete and the sound of him laughing when I got it on my shoes. That summer is one of the clearest things I carry. I became a deputy at 23, made sergeant at 30, chief deputy at 41. I was elected sheriff of Lafourche Parish in 2014, re-elected in 2018, and again in 2022 with 64% of the vote. I have spent my life in this parish. I've buried colleagues in this parish. I've watched it change, and I've tried to serve it honestly. When my father passed in 2019, the house came to me. I had been living there with him for the last 3 years of his life. There was no mortgage. There was no dispute. The deed transferred cleanly into my name. Parcel number 0042-11784, Lafourche Parish Assessor's Records. I want you to remember that parcel number. It comes back. In a way I did not expect. The house is not large, about 1,400 square feet, on a half-acre lot. My grandfather's shadow box is on the living room wall. A tarnished silver deputy's star from 1948, mounted behind glass, with a small card underneath in my father's handwriting that says, "For Clarence." He kept this all his life. I look at that star every morning when I leave for work. Now, here is the part I still cannot entirely explain. In 2021, a development company called Pelican Trace Properties began buying up parcels in a half-mile radius around my family's land. They put 73 new homes, They platted a subdivision. They filed CC&Rs, covenants, conditions and restrictions with the parish. They formed a homeowners association called the Bayou Trace Community Association. They sold those 73 homes to people who moved in and started paying monthly dues. My property was not part of the development. It was never annexed. It was never platted into the subdivision. My grandfather's deed predated the development by 70 years. My land sat in the middle of the new subdivision, the way a stone sits in a stream. The water just goes around it. That is what should have happened. The water should have gone around. It did not. The first notice arrived in my mailbox on a Tuesday in March of 2023. It was printed on a letterhead that said, Bayou Trace Community Association, Community Standards Authority. It listed 7 violations: unregistered vehicles in the driveway, an outdoor storage unit, not meeting architectural guidelines, a garden shed without HOA approval, a fence that did not match subdivision specifications, and 3 others that I cannot even describe without shaking my head. I'd never signed a document with that association. I'd never attended a meeting. I'd never paid a due. My property had never been legally incorporated into their CC&Rs, but the notice was addressed to me by name, listed my parcel number, and informed me that I owed $420 in fines due within 30 days. I looked at that notice for a long time. I have been in law enforcement for 31 years. I know what legally binding documents look like. I know what they say and what they do not say. This one had no case number, no statutory authority, no signatures from any elected or appointed official. It had a logo and a phone number. I set it in the pile on the kitchen table and I thought, this is a mistake. Someone included my parcel in error. I will make one call and it will be sorted. I called the number on the letterhead. A man answered. His name was Dale Pressler. I told him I had received the notice, that I believed there was a data error, and that my property had not been incorporated into the Bayou Trace CC&Rs. I was polite. I was clear. I gave him my parcel number. He said, and I want to quote this exactly because I've thought about it many times since, "Sir, I have the authority to require your compliance. Whether you believe you're subject to the CC&Rs or not, that's a matter for the board to determine, not you." I told him I was Elroy Beaumont, the sheriff of Lafourche Parish, and that I was confident the matter could be resolved by pulling the original subdivision plat. He paused for just a moment, and then he said, "I know who you are, Sheriff. That doesn't change anything here." I hung up and sat with that for a while. What came next was not a correction, it was an escalation. Within 10 days of that call, I received a second notice. This one cited additional violations and added an administrative processing fee of $250. The total alleged balance was now $940. The notice said that if the balance was not paid and the violations corrected within 15 days, the association reserved the right to pursue all available legal remedies, including property liens. I want you to understand what a lien means. When a lien is placed on a property, it attaches to the title. You cannot sell, you cannot refinance, and in some circumstances, you cannot transfer the property without satisfying it. A lien filed by an HOA, even a fraudulent one, can cloud a title for months or years. It requires legal action to remove. It costs money and time that most people do not have. Here is your knowledge nugget for today, and I want you to write it down. An HOA can only enforce its CC&Rs against properties that are legally incorporated into the association's recorded plat, or that have signed a deed of acceptance. If your property was never legally annexed, if you never signed a CC&R agreement, and your parcel was never included in the original or amended plat, a fine notice from that HOA is not legally binding. It is a piece of paper. But a fraudulently filed lien is still a lien until a court removes it. That is the gap they exploit. The paper may be worthless, but the damage it does to a title is very, very real. They were betting I would pay to make it go away. That is what Dale Press's business model was built on. I found that out later, but I am getting ahead of myself. I started documenting every notice, every postmark, every phone record. 31 years of law enforcement teaches you one thing above everything else. You do not act until you have the record. I did not know yet what I was building. I just knew that when something feels wrong at a structural level, not just wrong, but constructed, deliberate, designed, you build the record before you build anything else. What I did not know yet was that the fines were the opening move, not the main event. The main event was coming in September. I want to tell you what September the 7th felt like. I was home on a Saturday, off duty, or as off duty as a sheriff ever gets. I had been up early with coffee on the back porch, watching the light come up over the yard. My grandfather planted those cypresses on the east side of the property in 1963. I know that because my father told me, and I can see their age in the trunk spread. I was sitting in a folding chair watching those trees catch the morning light when I heard footsteps on the front porch. I came around the side of the house and there he was, Dale Pressler, in a press navy polo shirt, Bayou Trace logo on the left chest, khaki pants, clipboard in one hand, and on a lanyard around his neck, the badge, gold plastic, Community Standards Authority, the seal of a homeowners association that had no legal jurisdiction over my land. He looked at me without flinching and told me that Bayou Trace Community Association had voted at a special board meeting to escalate enforcement proceedings on my property, that I was in violation of 17 separate community standards, and that I had 48 hours to vacate the property while the association conducted a full compliance inspection. He used the word vacate. He said I needed to make arrangements. I looked at him for a long time without speaking. I looked at that badge, and I felt something I can only describe as a very old kind of quiet. Not anger, something slower than anger, the kind of stillness that comes when you realize the thing you are looking at is not just wrong. It is a studied, practiced, professional wrong, and the man performing it has done it before. I told him to get off my property. Calmly. Once. He told me I was interfering with official HOA proceedings. I told him, slowly and clearly, that I was the elected sheriff of Lafourche Parish, that he was standing on private property that had never been part of his association's jurisdiction, that his badge was a piece of novelty, plastic with no legal authority in this parish or any other, and that if he did not walk off my property in the next 30 seconds, I would arrest him for trespassing. He walked off my property. But before he reached his truck, a white pickup with a Bayou Trace Community Association logo on the door panel, which I noted, he turned and said, "This isn't over, Sheriff. The board has resources. We know how to use them." And then he drove away. Have you ever had someone try to use your front porch against you, your own front door, as the staging ground for their move? Tell me in the comments. Because what I felt standing there watching that truck pull away was not just anger at what had happened to me. It was the knowledge that somewhere in this parish, in this country, someone without a badge and without a uniform and without any law behind them had done exactly this to someone who had no way to push back. That person would have packed a bag. And that is the part that made my jaw set in a way it is never quite unset. Here is where the story shifts. I called Marguerite Fontenot that afternoon. Maggie, she has been the district attorney for Lafourche Parish for 9 years. We have worked together on everything from homicides to consumer fraud. She is a small woman with a very large voice and absolutely no patience for what she calls institutional cosplay. Her phrase for when private entities dress themselves up in the costumes of authority they do not have. I told her what happened. I read her the notices. I described the badge. She was quiet for a moment. And then she said, Elroy, pull his LLC filings. Pull the contract between his company and the association, and pull every lien he has ever filed in this parish. That was the instruction I needed, because I'd been thinking about this as a property dispute. Maggie immediately saw what it actually was. Here is what we found. Dale Pressler operated a private company called Gulf Coast HOA Compliance Services, LLC, registered in Louisiana in 2018. His LLC had contracts with 11 HOA communities across Lafourche and Terrebonne parishes. His service, he called it proactive standards enforcement. What that meant in practice was this. He identified properties that were adjacent to or surrounded by subdivisions, properties that had never been formally incorporated into the HOA's CC&Rs, and he sent them fine notices on association letterhead. He then offered to settle the outstanding violations for fees ranging from $2,000 to $18,000. In 6 cases, when property owners did not pay, he filed HOA assessment liens against their titles. Using a power of attorney, he claimed the HOA boards had granted him, which the boards later told investigators they did not recall authorizing. In at least 3 of those cases, the liens had been filed using a parcel number that did not belong to the property in question, including mine. But here is what I want you to remember. The lien on my property, he had already filed it. I found out 4 days after the porch confrontation when I ran my own parcel number through the parish mortgage and conveyance records. There it was, an HOA assessment lien for $3,215, filed on August the 19th, 17 days before he showed up on my porch with his clipboard and his plastic badge. He had filed the lien before the confrontation. The confrontation was not enforcement. It was a pressure campaign designed to make me panic and pay before I discovered the lien. And that is when it stopped being a property matter. I want to be honest with you about what came next, because the nights between that discovery and the resolution were not easy. Maggie moved fast, but the legal system does not move fast. We had a hearing scheduled for October the 28th. That was 6 weeks out. 6 weeks with a fraudulent lien on my family's land. 6 weeks knowing that Dale Pressler was still operating, still sending notices, still filing on people who did not know they could fight back. There was a night, I will tell you about it, where I sat in the chair under my grandfather's star, and I did not move for a very long time. Not because I was going to give up. I was not going to give up. But because the weight of it had a particular texture. This was my grandfather's land. This was the land he could not have owned in this parish 50 years before he bought it. Given what this state was then, he bought it anyway. He built on it anyway. He left it to his children, and they left it to me. And some man with a plastic badge and a printer and an LLC thought he could attach a lien to that deed like a note on a refrigerator. I looked at the star in the shadow box, at the small card in my father's handwriting, and something settled in me, not anger. It was the kind of clarity that does not need noise. I was going to walk into that hearing, and I was going to be very, very prepared. Then Dale Pressler made a mistake. 3 weeks before the hearing, someone tried to access my personnel file through the Sheriff's Department administrative portal using an external credential. The IT division flagged it and traced the access attempt to an IP address registered to Gulf Coast HOA Compliance Services, LLC. He was trying to dig up something to use against me, something that would make my testimony less credible, or give him leverage, or let him file a counter-complaint to the Louisiana Commission on Law Enforcement Standards. What he found was 31 years of commendations, a spotless disciplinary record, and a 2019 letter from the Governor's office acknowledging my department's work on a multi-agency anti-trafficking task force. But the attempt itself, unauthorized access to a law enforcement personnel system, was a criminal matter under Louisiana Revised Statute 1473(3), computer fraud, regardless of what he found or did not find. Maggie added it to the file. The hearing date was October 28th. That gave us 6 weeks. He had been building his operation for 5 years. We had 6 weeks, and we did not waste a single one. I want you to hear this clearly. A time constraint is not a weakness. A deadline is a forcing function. Every hour I had, I used. Every record I pulled, I copied twice. Every witness Maggie identified, she reached before he could. 3 of the 11 HOA boards he contracted with cooperated voluntarily once investigators made contact. 2 of them had received complaints from homeowners about unauthorized liens they had never authorized. The boards thought his company was filing on legitimately delinquent accounts. They had not known he was targeting properties outside the subdivision plat. 2 days before the hearing, Dale Pressler's attorney contacted Maggie's office with a settlement offer. He would voluntarily withdraw the lien, dissolve the contract with Bayou Trace, and pay my legal fees if I agreed not to pursue criminal charges and to issue a public statement that the matter had been resolved amicably. Maggie called me and read it to me. I told her no. The hearing was in the Lafourche Parish Civil District Court, Judge Elaine Toureau presiding. I wore my dress uniform, not as a statement. That is just what you wear to court in this parish, when you were the sheriff. But I will not pretend the effect in that room was nothing. Dale Pressler was there with his attorney, a man named Keith Bergeron, who I had seen in that courthouse a dozen times over the years, and who, to his credit, looked like he already knew how this was going to go. Pressler himself was in a grey suit, no clipboard, no badge. Without those props, he looked like what he was, a private contractor in a grey suit who had made a systematic habit of filing fraudulent property instruments on people he calculated could not fight back. Maggie presented the case. She was methodical. She entered the LLC filings, the 11 contracts, the 6 fraudulently filed liens, the parcel number discrepancies, the unauthorized computer access attempt, and the 3 HOA board affidavits stating they had never authorized liens on properties outside their recorded plats. Then she entered the history of Parcel 421784, the 1951 deed, the 1984 improvements, the 2019 transfer, the chain of title, unbroken, across 72 years. Judge Toureau looked at that chain of title for a moment. She looked at Pressler. She said, "Mr. Bergeron, am I reading correctly that your client filed a lien on a property with a recorded deed predating this entire subdivision by 70 years? Bergeron said, "Yes, Your Honor," she said. "How?" Bergeron did not have an answer that satisfied her. The lien was vacated. The court ordered Pressler to pay my legal fees, $14,600. It referred the matter to the Louisiana Attorney General's Office for investigation of the remaining 11 contracts. 3 months later, Gulf Coast HOA Compliance Services, LLC, surrendered its business registration. Pressler entered a deferred prosecution agreement on the computer fraud charge, with conditions including permanent prohibition from contracting with any HOA in the state of Louisiana. I did not smile when the ruling came down. I sat steady, the way you sit when you have been carrying something heavy for a long time and you finally set it down. Not relief exactly, something quieter. I looked across the room. Pressler was talking to his attorney in a low voice, his back half turned. He did not look at me. He never looked at me. The day after the hearing, a Thursday, I got up early, made coffee, took it out to the back porch the way I have every morning that I am home. Watched the light come up through those cypress trees my grandfather planted. The air smelled like it always does in the morning here. Bayou water and cut grass and something sweet I have never been able to name exactly. I went back inside and stood in front of my grandfather's shadow box, the tarnished silver star, the small card in my father's handwriting. I thought about Clarence Beaumont, who worked sugarcane in this parish for 40 years and then went down to the courthouse and signed a deed for a piece of earth that was his. I thought about what it took for him to do that in Louisiana in 1951 and what he understood that deed to mean. He kept that star all his life. My father wrote that card, framed it, hung it on the wall where I could see it every morning. He said he had the authority. He had exactly as much as I gave him, which turned out to be none. Here is what I want to leave you with. Your name on a deed is not a courtesy. It is a legal ownership interest with a 72-year chain of title behind it if you are standing where I was standing. But even if your deed is 30 years old, or 10 years old, or 2 years old, it is yours. No HOA board, no compliance contractor, no polo shirt with a logo on it, no plastic badge can remove it without due process of law. And due process of law requires courts, and courts require evidence, and evidence is something you can build. Pull your deed right now, know your parcel number, know what subdivision plat your property is legally associated with. If someone sends you a fine notice from an association you never joined, before you pay a single dollar, go to your county recorder's office and pull your own title history. Look for liens, look for encumbrances, look for anything that was filed on your property that you did not authorize, because the people who do what Dale Pressler did count on you not looking. Don't let them be right. My name is Elroy Beaumont. I am 58 years old. I am the sheriff of Lafourche Parish, Louisiana. I still live in the house my grandfather built, and I did not walk away from what he left me. Neither should you.